Can employers claim undue hardship for bipolar accommodations? Imagine trying to get a workplace adjustment to help manage bipolar disorder, only to hear that it's too hard for the employer. It's a question many employees wonder about. Under the law, yes, employers can claim undue hardship when denying accommodations for bipolar disorder, but this claim is very limited and carefully scrutinized. Understanding what qualifies as undue hardship is key for anyone with bipolar looking to get support at work. The legal definition of undue hardship comes from the Americans with Disabilities Act and the Rehabilitation Act. It means that providing the accommodation would cause the employer significant difficulty or expense. This could be a big financial burden, or it might disrupt the business's normal operations. It also includes situations where the accommodation would fundamentally change how the business functions. The important part is that the hardship must be real and substantial, not just a minor inconvenience or a slight cost increase. There are things employers cannot claim as undue hardship, even if they seem burdensome. For example, fears or prejudices about mental health conditions do not justify denying accommodations. Concerns about employee morale or minor disruptions are also not enough. The law aims to protect employees with bipolar disorder from discrimination based on stigma or misconceptions. However, if an accommodation would seriously disrupt other employees' ability to do their jobs, an employer might have a stronger case for undue hardship. This balance ensures that workplace needs are considered fairly. When an employee requests an accommodation that seems reasonable, the burden shifts to the employer to prove that providing it would cause undue hardship. This means employees with bipolar disorder do not need to prove that their request is perfect or ideal. Instead, employers must show why it would create a significant problem. This legal approach helps protect employees from having their needs dismissed without proper analysis. The process usually involves an interactive dialogue between the employee and employer. During this conversation, the employee explains their condition and how it affects their work. Medical documentation may be needed to support the request. Both sides work together to find solutions that help the employee manage their bipolar disorder without causing undue hardship for the company. Common accommodations for bipolar disorder include flexible work hours, adjusted deadlines, breaks, changes to the workspace, or modified job duties. These adjustments are often simple and inexpensive, making it hard for an employer to claim undue hardship. For example, allowing a flexible schedule to help manage mood swings or providing a quiet space for breaks can make a big difference without disrupting the business. If an employer denies an accommodation claiming undue hardship, employees have options. They can ask for reconsideration or seek help from the Equal Employment Opportunity Commission, which enforces disability laws. Consulting healthcare professionals and employment lawyers can also strengthen the case by providing expert opinions on how specific accommodations would support the employee's health and work performance. Employers covered by the Americans with Disabilities Act, which includes businesses with 15 or more employees, have a responsibility to evaluate accommodation requests carefully. They should consult with healthcare and human resources experts before claiming undue hardship. This cautious approach helps avoid legal issues and ensures that employees with bipolar disorder receive fair treatment. In the end, the law aims to protect individuals with bipolar disorder by making sure that claims of undue hardship are genuine and based on real challenges, not stereotypes or minor inconveniences. While there are circumstances where an employer can refuse accommodations, these are narrowly defined and subject to legal review. Everyone benefits when workplaces are inclusive and understanding, balancing operational needs with the rights of employees to manage their health effectively. Remember, always consult healthcare and legal professionals for personalized advice, as each situation is unique.